Stalking offences in the UK are addressed through a combination of specific statutory provisions and general criminal law. The legislation has evolved over the years to better protect victims and address the serious harm that stalking can cause. Below is an overview of the key laws and provisions related to stalking in the UK. The primary legislation governing stalking in the UK is the Protection from Harassment Act 1997. This act was originally introduced to tackle harassment more broadly, but has since been amended to specifically address stalking. Section 1. Prohibition of harassment prohibits a person from pursuing a course of conduct that amounts to harassment of another, where the perpetrator knows, or ought to know, that it amounts to harassment. Harassment is defined as conduct that causes the victim alarm or distress. Section 2. Offence of harassment. Under this section, harassment is a criminal offence. The penalty for this offence can include imprisonment of up to 6 months and/or a fine. Section 2A. Stalking, introduced by the Protection of Freedoms Act 2012. This section specifically criminalizes stalking. It defines stalking as a course of conduct that amounts to harassment and includes acts associated with stalking, such as following someone, contacting them repeatedly, monitoring their activities, or watching or spying on them. Section 4. Putting people in fear of violence. Provides for more serious offences where the conduct not only amounts to harassment but also causes the victim to fear that violence will be used against them. The penalty for this offence can include up to 5 years in prison. Section 4. Stalking involving fear of violence or serious alarm or distress. Also introduced by the Protection of Freedoms Act 2012. This section criminalizes stalking where it causes the victim to fear that violence will be used against them, or causes serious alarm or distress that has a substantial adverse effect on their day-to-day activities. This offence carries a higher penalty, with imprisonment of up to 10 years. The Protection of Freedoms Act 2012 significantly strengthened the legal framework around stalking, recognizing the need for more specific laws. These provisions were introduced to address the serious psychological harm stalking can cause and to give law enforcement better tools to protect victims. The Stalking Protection Act 2019 introduced Stalking Protection Orders (SPOS), which are civil orders designed to protect individuals from stalking. An SPO can be applied for by the police and can impose restrictions on the stalker, such as prohibiting contact with the victim or entering certain areas. Breaching an SPO is a criminal offence, punishable by up to 5 years in prison. PACE provides general powers of arrest and investigation, which are used in the context of stalking offences. The Act allows the police to arrest individuals suspected of stalking and to gather evidence through search and seizure.